Good day, Crime Talk aficionados. Thanks for joining us. We have a great show for you today. First, the Circus is headed to Ada County for the Bryan Kohberger case. And guess what? The real press doesn't like where they get to sit. Luigi Mangione's attorneys say unshackle their client. A short day in the Karen Reed trial. Ooh, I can hardly wait what people are going to call me today. 3 missing sisters are found in Washington state. And, well, let's just say it didn't end well. The shocking motive for the death of the King of the Hill television show star. A man tries to kill his wife by driving into another car head on. A new technique indeed. This day in legal history, our quote of the day deals with witness memories, and then our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. Thanks for joining us. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. But before we get to the docket, let me remind you to go to CrimeTalkSearch.com, where you can sign up for a background subscription service. And when you do, you'll be able to do a background search on anyone here in the United States. The report is literally prepared and sent to you while you wait, and that report is going to have information about the person you're searching for. For example, what phone numbers are associated with that person? What emails are associated with that person? What is their social media presence? Do they have liens, judgments? Are they married? Are they divorced? Do they have a criminal history? Are they on one of those, sex offender registries? Things that you may want to know about somebody that they're maybe not going to volunteer to you, at least when you first get to meet them. But hey, if they're a loser, don't waste your time. Find out early and dump them. Go to CrimeTalkSearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and open the record for Wednesday, June 4th, 2025. And first on the docket, well, the Circus is coming to town. They're in Ada County. And guess what? The real press doesn't like it because they don't get reserved seating. That's right. Ada County is about to get its third major trial of national interest in more than 2 years. And while the county's experience with the trials of Lori Vallow and Chad Daybell in 2023 and 2024 offers some valuable insights, the upcoming trial of Bryan Kohberger promises to be of even higher interest and set up the 3 rings, ladies and gentlemen. Now, there was a media briefing with the District Judge James Cawthorn the other day, and the Ada County Courthouse could turn into this circus that I've mentioned. So apparently there were at least 100 people that were on that call with the judge, including obviously local journalists, the Associated Press, as well as national reporters from ABC, Fox, NBC News, etc. Now, the national journalists were asking about parking for reporters and TV trucks, reserving areas for live shots in the front of the courthouse, as well as allowing tents outside the courthouse during those summer days once the trial begins in August. One reporter even suggested allowing scaffolding to be erected so that all the TV live shots can be done from up above. Now, compared to the Vallow and Daybell trials, like I said, this is going to be a big one. And to the judge's credit, he emphasized that however big this trial is, the goal is to continue to allow the normal operations of the courthouse with as many as 300 other trials going on during the Kohberger trial. I mean, that's a lot of trials, 300, but depending on how you count it, they're probably set. Anyway, so several media outlets are requesting that the court allow a pool still photographer in the courtroom, that the court reserves at least 1 seat for pool text journalists that could make individual camera feeds available from the live stream that the court is providing, and that the court consider lifting the non-dissemination or gag order during the trial. Now, most people in the press, and certainly I've been a free speech advocate because we are, so I would support all those requests. But apparently what the press sees as a big flaw in these proposals is that the way the judge is handling seating. As of right now, the court will use a daily reservation system in which the public will have to request a seat in the courtroom by logging in at noon each day for the following day's court appearance. Apparently, one reporter characterized this as you basically have to buy like you're buying a concert ticket. And I'm trying to think. I used to have my ticket from the Lori Vallow trial here. I don't know what I did with it. I guess I'll find it. But I had it because when we were out there and you had to get your ticket for the overflow seating, it all worked out. Would I have loved to have been in the courtroom? Yeah, but it's a very small courtroom. So when you have reserved for family and support staff, that's kind of just the way it has to go. Don't get me wrong. I would love to have a seat right there. Anyway, so the press, the mainstream media press says that they shouldn't have to be subjected to such things as the general public is going to have to do. So this system apparently no way ensures journalists have a seat at such an important trial. And the press is complaining this actually hamstrings who might be in the courtroom working at noon or at the courthouse filing stories, going live with a report, filling out the courtroom when the system goes live, or simply working on another story at that particular moment. So the press is upset that this reservation system favors, as the media's letters to the court points out, those with free time on their hands and the fastest internet connection at the moment. Well, if you know that's the system, I guess you better upgrade your internet service and maybe plan on scheduling at that particular time, or delegate that to somebody in your office to get that seating assignment, wouldn't you think? Instead of just complaining about it, right? Didn't they always teach you that in the military? Hey, next time you come to me with a problem, why don't you come to me with a solution as well? Seems like a pretty simple one. Anyway, the press is not happy about it because guess what? All these seats could go to people that have YouTube shows and are just going to bring you the facts. And apparently anyone that has a YouTube show and is not a traditionally trained journalist simply cannot bring the news to you as anyone else. So anyway. So the press is saying that the best solution at a minimum is to allow at least one pool reporter and a trained journalist from a legitimate, reputable news outlet who will report from the courtroom with a guaranteed seat each day to provide a written account shared with every news outlet. Even better would be a pool reporter along with 3 or 4 guaranteed seats for journalists that a random lottery system could determine is their proposal. Anyway, the press says whatever system is chosen, the bottom line is that for such an important trial as this, it is vital that the media have a presence in the courtroom each day, relay the events to the public. And the current system apparently just doesn't guarantee good enough seating for the trained journalists. Because the trained journalists, they ask questions like, who was involved? What happened? Where was it? What happened next? Oh my gosh. Or even better yet, the court should obviously stream it, which they've said they're going to do, which is the best thing so that people can actually watch it and see it and judge it for their own eyes as well. Anyway, the mainstream press says that they provide an impartial eye into the co-equal branch of government and that their work helps to protect democracy by ensuring a well-informed citizenry. Now, I certainly do like a well-informed citizenry, and I have for a long time said the courtrooms should be open to everybody. I mean, obviously, you have a Sixth Amendment right to a public trial, but that should include basically live streaming every courtroom in the country. There shouldn't be any limitations on it. Everybody should be able to see what goes on in any courtroom, anytime, anywhere. So, although I support, access to the courts, as somebody that works in the courts on a daily basis, I believe that people should see what's taking place. Are people being zealously represented? Are the judges being fair and impartial to both sides? Is the prosecutor seeking justice and not just being mean-spirited? Those are the type of things that we should see. I disagree with the press saying that, oh my gosh, you must be a trained journalist to do that, and somehow that they are impartial. I provide commentary on the news. I don't I tell it the way I see it. We'll talk about that in a minute. But anyway, we'll see what happens to the circus. We've definitely blocked out some time, and since the trial is going to be there for several months, we'll still be able to jump on CrimeTalk 1 and go check out the trial. Maybe I can put in for my media credentials to get into that seated pool. Wouldn't that be great? I think it would be. Next, let's talk about Lori Vallow. So the judge in the Lori Vallow, Judge Boreski, ordered that the sheriff's office bring Lori Vallow from jail to the courtroom after she left the proceedings early 2 days ago because she was wheelchaired into court on Monday in a wheelchair, telling the judge she had headaches, nausea, and chills. With a trash can next to her, Ms. Vallow said that she basically could not get out of the wheelchair. She said, quote, "I'm sick, Your Honor. I've been sick all weekend. I let my team know yesterday I was sick," end quote. The judge ended court proceedings early on Monday and announced that jury selection would resume on June 4th. Vallow obviously is accused of conspiring with her late brother, Alex Cox, in the attempted murder of her ex-nephew-in-law, Brandon Boudreaux. Now, Boudreaux was shot at outside his Gilbert home in October of 2019. And while Boudreaux was not hit, the incident is linked to a series of deadly events in Idaho, including the murders of Vallow's two children, Joshua J.J. Vallow and Chad Daybell's first wife, Tammy, as well as Tylee. In April, Ms. Vallow was also found guilty of plotting to fatally shoot her fourth husband, Charles Vallow. And then in late breaking news, the judge ordered that Lori Vallow be evaluated by the doctor, and he wanted some sort of report, certainly not violating any HIPAA laws because we don't want to do that, right? But just to see if she is in fact sick. Now, obviously, if she's sick, she's entitled to a continuance. And if she is malingering because she thinks that she's going to somehow get away from this particular judge that she does not like and has filed several motions to recuse, well, that's not going to work either. Either way, when it happens, we will bring it to you. Next on the docket, Luigi Mangione's attorneys say, unshackle my client. Now, sometimes we just give you a quick summary. Other times I think it's important to, well, let's go to the actual pleading. But in the Southern District of New York, they file letters with the courts, literally letters, although it's supposed to be a motion. And the attorneys for Luigi Mangione said, "Dear Judge, we respectfully request that during the next court appearance on June 26, that Mr. Mangione be permitted to have his hands unshackled while seated at the defense table, and he be permitted to wear court-appropriate clothing without a bulletproof vest." Seems like a reasonable request, does it not? The authorities, both state and federal, have already prejudiced Mr. Mangione in the media more than virtually any defendant in recent memory. This commenced with the New York City mayor-led staged perp walk, and it continues until today. These same authorities should not use Your Honor's courtroom and Mr. Mangione's court appearances to perpetrate false narrative that Mr. Mangione is an unusual danger requiring an extraordinary security measure. There is no disputing that he has been a model prisoner, a model defendant in court, and has treated everyone in the court and prison system with cooperation and respect. These deeply prejudicial security measures, which are invariably photographed and circulated in the public, including potential jurors, are unnecessary and should not continue as they are damaging to Mr. Mangione's right to a fair trial. Our narrowly tailored request, which is in the court's discretion, is that Your Honor permit Mr. Mangione, when seated at counsel table, to be treated like other defendants and have his arms unshackled and no bulletproof vest, which he is now appeared in federal court in December 2024 and April 25, out the need for counsel to request these conditions. Footnote: to provide a reasonable compromise, we are not requesting that his legs be unshackled for the court appearance. This is in no way, however, indicates that we believe there is a need for his legs to be shackled, as we do not believe him to be a flight risk or a safety risk either. So wearing handcuffs and a visible bulletproof vest in court unfairly prejudices Mr. Mangione and impedes his right to effectively defend himself for no justifiable reason. Notably, when counsel made a request to unshackle Mr. Mangione at the February 21st, 2025 court appearance, this court initially responded, "Go ahead and uncuff him." After a court officer approached the bench and had an off-the-record conversation with the court without counsel present, Your Honor stated, for security reasons, they want him cuffed. Without elaborating what the security issues were, the court then allowed counsel to make the following record. This is a highly publicized and covered and photographed court proceeding with strong public interest. And when my client comes to court, because he's in federal custody, they bring him in, they walk him in leg shackles, arm shackles. They have him sitting here, and there is no presumption of innocence. I'd like to let you know I go visit him regularly at the MDC, where we sit in a room. He's completely unshackled. He is a model prisoner at MDC. There has not been an issue. He has not given the police one single problem, and there is no reason for him to be this way in court when all these officers are standing here. In response, the court noted as follows: I understand that, but for security reasons and for the security people, they would prefer him to remain cuffed. Courts have long recognized that visibly shackling a defendant in front of a jury is prejudicial, and thus they should not be physically restrained unless it is justified by a special need specific to the defendant, such as a defendant's behavior or risk of escape, neither of which are present in this case. In Deck v. Missouri, the Supreme Court noted that the law has long forbidden routine use of visible shackles during the guilt phase. Rather, the Constitution requires that a defendant can only be shackled in the presence of a special need. The Supreme Court stated 3 reasons for this decision. First, the criminal process presumes the defendant innocent until proven guilty, and this bedrock of criminal justice is undermined by shackling because it suggests to the jury that the justice system itself sees a need to separate a defendant from the community at large. Second, shackling a defendant can only interfere with the accused's ability to communicate with his lawyer and his ability to participate in his own defense, both rights guaranteed by the Constitution. Third, judges must seek to maintain the judicial process that is in a dignified process. For these rulings, the court, the due process does not permit the use of visible restraints if the trial court has not taken account of the circumstances of this particular case. Then he goes on and cites some New York case law, but you get the gist. Now, obviously, I've had unruly clients. I've had clients that have literally been chained to the floor during trial, have stun belts on them, obviously outside the presence of a jury. I understand the request, and the jury should never see anybody shackled, ever, because that would be a violation of one's due process right and the presumption of innocence. However, here we're talking about pre-trial. And here's the thing. The courts are normally going to listen to the marshals in this particular case or the personnel, court security personnel, as to the safety considerations. Now, obviously, that's not going to take place during the trial, but they'll probably have a stun gun or something if he was attempted to escape. But there's nothing to indicate that Mr. Mangione would do that. So it seems like a reasonable request, but judges normally will defer to the police officers in handling the situation. So you have to be obviously mindful of that, particularly at trial. But here we're talking about pre-trial. Okay. Most people in custody come to court in their prison greens. They'll have leg shackles on. If not leg shackles, they'll certainly have their hands handcuffed. And that's obviously for security reasons. And second of all, it's so difficult these days because of understaffing to even get clients over to the jail in a timely manner. And when there's 35 people in custody on a particular docket on any particular day, the sheriff doesn't have time to dress everybody out individually so that when the world is watching, that they don't see them in jail garb and handcuffs. So I get it. I think, the attorneys should do that. I've had clients that have been shackled, and normally, you say, Judge, it's a pretrial hearing. Can you unshackle my client because he would like to take notes and assist in his representation? And normally the police officers realize that nobody is going to be doing anything that would signify that there's a danger or a mistake. If not, guess what? That sheriff deputy is going to take the defendant out real quick because he usually has his legs shackled. And if they do take the shackles off his arm, it may be chained to the chair as well. So I think the feds in this particular case are going a little overboard on the security for Mr. Mangione. I'm sure I offended somebody on that. But hey, if you really want to offend somebody, let's talk about the Karen Reed case. Wow, ladies and gentlemen, appreciate you guys helping our engagement go through the roof on the Karen Reed case. And I love people, Scott, I normally agree with you, but you're so wrong on this, to people saying I'm the biggest idiot. Did I ever even go to law school? And that means so much to me when I get criticism about my critique of how a case is being handled from somebody that has never, ever, ever, ever tried a criminal case in a courtroom in their life. So it is what it is. My opinion is that the defense has not been hitting it out of the park. I think it's been weak at best at this point. Now, you got people in the Karen Reed can do no wrong camp that disagree with me, and they let their comments be known. And then you got the people that, Karen Reed obviously did it. And they, of course, said I was the greatest attorney ever and greatest analysis whatsoever. Now, don't get me wrong. That can completely change based upon if something impactful happens. I've said that before. Hey, this is my opinion based upon the information that we have. And guess what? My opinion, just like in real life, is subject to change based upon new information. Now, let's talk about today's information. Has anything changed? Well, let's talk about it. First, in the Karen Reed case, court resumed about a little after 9 o'clock this morning, and the judge said that the defense attorney, Mr. Yannetti, had requested a sidebar. And after several minutes of discussion, the jurors were finally brought in close to about 9:30 to get started. Now, it was going to be a half day of court today, and no court tomorrow because it's going to be very hot, and apparently there's no air conditioning in the building, so they will resume again on Friday. Once again, making this the longest hit and run trials in the history of America. Any courtroom I've ever been in, and I just had one set, basically hit and run, somebody died. We were set for 4 days. And it's an ID case as well. I mean, if the judge told me, I just did the last big trial I did. When I say big, every trial is big to every particular client, but long, which was 4 weeks. That was last year, but we had multiple victims. We were up to 9 plus a bunch of other 404B witnesses in a human trafficking case. And we were able to get that done. And we worked till 9 o'clock some nights, dealing with legal issues and jury instructions issues as well. I don't know what people are like, oh, we got to 8 weeks blocked out. We're in no rush. Let's just move along. Very inefficient when these big high profile cases come along. Anyway, first witness today, Bryan Loughran, the snowplow driver who testified in the first Karen Reed trial, had taken the stand today. Now, he started by testifying about attending Canton schools and how he knows the Albert family from his school years, and because he worked delivering pizzas for Chris Albert when he was in his 20s. Now, Mr. Loughran's brother, Chris Albert, is also a select board member there in Canton. Now, Mr. Loughran testified that he was working as a snowplow driver with the Canton Department of Public Works in the early morning hours of January 29th, 2022, when John O'Keefe was found in the snow on the lawn at 34 Fairview Road. Now, Loughran said he was familiar with the address because he regularly delivers pizzas to Bryan Albert's home, usually on Sundays. He testified that he started his snowplowing shift at 2:15 a.m. that day and testified about what he can see from the truck and how bright the headlights are. As far as my eyes would let me see, he said, was when how far he could see from the truck. He also described his various plowing techniques that he uses as a plow driver. Now, Mr. Loughran then talked about his plow route, including Cedar Crest Road on the morning of January 29th, as he approached 34 Fairview Road back in January of 2022. He said the first time he drove by Fairview Road, he plowed Cedar Crest Road and then returned to the intersection of Cedar Crest and Fairview, taking a right onto Fairview Road. He said he was very, very familiar with 34 Fairview Road, having grown up in the area and delivered pizzas to that specific address. When he entered Fairview Road for the first time at about 2:40 to 2:45, he said 34 Fairview Road was on his right. He said he knew that Bryan Albert, a Boston police officer and a first responder, lived at the home. Now, Mr. Loughran said that he could see the front lawn all the way to the front door and did not notice any obstructions when he was plowing the road. He said he's constantly scanning the road. Now, he said he saw the area of the flagpole on the Albert's lawn and that there was nothing on the lawn that he observed. Now, asked if he saw a 6'1", 215-pound man lying on the lawn, he replied no. Now, Loughran said he continued plowing and then returned to the area of 34 Fairview Road on a second pass about 10 to 20 minutes later. He said there were still no obstructions keeping him from seeing the front lawn, and he again did not see anything on the lawn at that time. He said he saw nothing. He said he returned to the Fairview Road area again for another pass about 45 minutes later, about 3:30 a.m. And at that point, he said the weather had gotten worse and it was snowing quite hard. Now, Loughran estimated that there might have been 2 to 3 inches of snow on the ground. And he said he could still see pretty well, clearly in front due to the lighting on his plow truck. He said specifically, quote, "As I make my right onto Fairview, I noticed there's a vehicle on the right-hand side, roughly in the area of the flagpole in front of 34 Fairview Road," he said, end quote. He said that the vehicle was a Ford Edge and it was parked nose going up Fairview toward Chapman Street. He said it was parked adjacent to the Albert property between the flagpole and the front door. He said he remembered the vehicle because he had never seen a vehicle parked in front of the home like that, because there was ample parking in the driveway. He also said there was no parking allowed on streets during snowstorms. Now, Mr. Loughran said procedure called for him to report the vehicle parked on the street so it could be towed, but he chose not to report it out of respect for the Albert status as a police officer and a first responder. He said he had to go around the street because the vehicle was parked on the street. As he drove past 34 Fairview Road, Loughran said he saw nothing on the ground by the flagpole yet again. About 5 minutes later, Loughran and his plow did one more pass by 34 Fairview Road and saw the Ford Edge still in the same location. He again was asked what he saw in the area of the flagpole, and he said that he saw nothing. Mr. Loughran said he continued plowing in other areas of town, not returning to the Fairview Road area until about 3 hours later at about 6:13 a.m. This time, as he turned onto the road, he noticed the blue police lights behind him, and he pulled over to the side of the road. He said he continued down Fairview Road afterwards. He said specifically, "I noticed the police cars had the road blocked off, preventing me from going to Cedar Crest." He said that the police vehicles had their blue lights on and were parked blocking the entire road. He said that that was very well lit at that time. He turned around at Carriage Lane and continued to plow that road, eventually exiting to the left toward Chapman Street. Mr. Loughran said he eventually returned to the area to finish the plowing after the police left. And Mr. Loughran said he first heard from anyone involving this case 2 weeks later when a defense investigator reached out to him. He was asked if the former Massachusetts State Police Trooper, Michael Proctor, the lead investigator, had ever contacted him, and he said that he had not. Mr. Loughran said he later met the defense investigator and drove his snowplow route with him. At a later date, Loughran said he met the other investigator who were not involved with the state or the Canton Police Office. Eventually, after he had already spoken to the defense and the other law enforcement officers, Loughran said he had heard from the state police. Now, Mr. Loughran asked how clearly he remembers what he saw on Fairview Road that night, and he said, very strong. Then, Mr. Brennan asked on cross-examination if he'd ever felt intimidated or threatened, and he said he had not. When Mr. Brennan asked if he had been threatened to be exposed by an online blogger if he wasn't helpful, Brennan didn't name the blogger, but appeared to be referencing Aidan Kearney, also known as Turtle Boy. Take a look at these little clips of Turtle Boy talking about Mr. Loughran.
Because he's a big, lucky pussy. That's what he is. He's a big pussy. And he's a lying piece of shit who knows about the fact that John O'Keefe was not there. He can testify to it, and he's choosing not to. So every single person out there defending this useless thing, Lucky Loughran, he can burn in hell with the rest of them. And by the way, this is the most important witness in this whole thing, is Lucky Loughran. And so all these people like, oh, his wife died. Okay, I'm sorry your wife died. Sorry, but you don't get to play the victim card and obstruct justice, because Lucky Loughran is a useless county piece of shit who is covering up a murder. All right, so I didn't cover a couple things earlier in the first thing I want to get to is the Lucky Loughran thing, because I saw people in the comments feeling bad for this guy. I hate this piece. This guy's an ass. Lucky Loughran. So his name is Bryan Loughran.
Anyway, Mr. Loughran says he was not threatening. Now, Mr. Loughran said he did not listen to podcasts about him, but people did tell him about the podcasts. He said he didn't know how large or what his presence were, but he knew that the guy had a blog. And Mr. Loughran said he follows the blogger, but does not pay for a subscription. And he is aware of the blogger's power and ability to harass, as Mr. Brennan put it on cross-examination. Now, Mr. Loughran said he was at the time dealing with the loss of his wife, and he was not paying attention to the online chatter about the case. He said he received a call from a blogger and was aware of the communication that it was shared online. Brennan asked if he enjoyed the attention from the blog, and Mr. Loughran said he did not, but he acknowledged he did pose for photographs with people associated with the blog. And he said he was just trying to be polite and trying to avoid any sort of confrontation whatsoever. Mr. Loughran said he was not looking for any attention, rather it was brought to him. Now, Mr. Brennan next asked Mr. Loughran about the date of May 24th, when he met with investigators not associated with the State and Canton Police Department. Brennan said in previous interviews that Mr. Loughran gave a different account of the times he passed by Fairview Road in his testimony. The prosecutor then grilled Mr. Loughran on how good his visibility was on the morning of January 29th when O'Keefe was found in the snow at 34 Fairview Road. Brennan then asked if he viewed every yard and not just 34 Fairview Road, to which Loughran said that he did. Brennan asked if he remembers which yard had a dumpster in the front yard. Mr. Loughran said he didn't remember that big dumpster in the front yard. He said, quote, "I looked, I saw, I didn't see a dumpster. That would have definitely stuck out," Mr. Loughran said. Plan on in the prosecution's case in rebuttal, somebody to talk about a big dumpster in the yard nearby. Anyway, Mr. Brennan asked if Mr. Loughran had any problems paying attention while driving and whether he had hit any while plowing. Well, Mr. Loughran said he did strike a portable basketball net with this plow that evening, or I guess early morning hours, and he said he saw it, but he just didn't adjust properly to it. Mr. Brennan showed the police dash cam footage from outside 34 Fairview Lane there, and in the video the jurors have seen earlier in the trial, and he asked Mr. Loughran if he could spot his vehicle in the video, and he had further questions about the route placement of the vehicle and other observations. Mr. Brennan also asked Mr. Loughran about Bryan Albert and his description as a first responder, and after some additional questions, Brennan wrapped up. Unity returns for redirect. Then Mr. Brennan asks Mr. Loughran about media reports concerning his testimony in the original trial. Now, the focus is photographs of Mr. Loughran, which posted publicly before his testimony in the original trial. And according to Mr. Brennan, this was an attempt to draw connection between Loughran and the Alberts. Now, Loughran has confirmed he knew Bryan Albert as a first responder. You knew that person and they were putting out private pictures of you online. I did notice, Mr. Loughran confirmed, going to say that he had not given his permission for those photos to be released. Was it embarrassing that they were doing to you? And Mr. Brennan asked. I wouldn't say embarrassing, it's more as aggravating, Mr. Loughran replied. Mr. Brennan characterized this as Mr. Loughran is being harassed. He then moves to add photographs into evidence that came out after the testimony. And Mr. Brennan described this as showing that Mr. Loughran is now embraced rather than attacked. Mr. Loughran agrees with that characterization. The defense then called Karina Kolokithis to the stand, and she is a Canton resident with 2 daughters. She met Jennifer Matthew McCabe and John O'Keefe through her children's sports. Direct was handled by Mr. Yannetti for the defense, and he began by asking about the nature of their relationship. The witness testified about her interactions with Karen Reed and John O'Keefe at the Waterfall Bar and Grill in Canton on the night before Mr. O'Keefe died. She said O'Keefe and Reed seemed very affectionate on that particular evening, and at one point O'Keefe even kissed Reed on the forehead, which the witness said she thought was very sweet, something she had never seen. The defense attorney, Mr. Yannetti, also walked the witness through a video from the bar that night showing O'Keefe kissing Reed with Brian Higgins nearby. The witness said that she left the bar around midnight with Reed and Jennifer McCabe, while her husband, Matt McCabe, stayed behind to help the band clean up. She said Chris Albert, Bryan Albert, and Higgins remained at the bar. The defense continued to show a video from the Waterfall Bar and Grill to the witness. She again said that she left the establishment with Miss Reed and Jennifer McCabe. She said, as we were leaving, Jen went over to Karen, kind of put her arm around her, and she started saying, "You're coming with me. You're coming with me." And Karen kind of like, "What? Where are we going?" End quote. It was just strange, the witness said. It was just stood out. Anyway, Reed did not go with McCabe, however, instead leaving O'Keefe and walking back towards Reed's vehicle. The witness said she had no concerns about Reed driving that night, and apparently she's a pharmacist, so she apparently says that she had no concerns, that Karen Reed was had over-imbibed. She said her last image of Reed and O'Keefe was the two of them walking towards Reed's SUV. That was the extent of the direct examination, and then cross-examination was very brief as well. Brennan took only a few minutes to cross-examine the witness, asking if Miss Reed was walking towards the driver's side of her SUV when she last saw her. Mr. Brennan then asked the witness if it was a celebratory mood at the waterfall that night, and she said that it was. He asked if the witness last saw Reed hugging Jennifer McCabe at some point, and she said she did. Brennan then asked the witness if she would describe O'Keefe as kind, generous, thoughtful, and soft-spoken. And once again, she said that she would. He also asked her if O'Keefe was a bit different that night because he was proud that his niece had just gotten into a private school. Again, the witness agreed. At that point, Mr. Brennan concluded his cross-examination, and Mr. Yannetti had no questions for redirect. So here's the analysis. Once again, any of these witnesses hit it out of the park. Tow truck driver says he didn't see a body, the body of Mr. O'Keefe, at the house in question when he was out plowing. Did he see this little Ford car out front as well? That will be a question of fact for the jury to decide. Now, what Mr. Brennan did was he, through prior inconsistent statements, impeached Mr. Loughran as it related to a different timeline that he had originally given to police officers, not the timeline that he had given to the defense investigators. So, once again, jury needs to decide. Now, could it be that Mr. Loughran, that's how he recalls it? Absolutely. And that could be exactly the way he recalls it. Doesn't mean he's lying. It just means that's what he believes or what he recalls that as being. But then when confronted with actual video where it shows him at various times on video at the scene when it's blocked off by police, he admits that that's his truck, which doesn't correspond with his timeline of events. Once again, a jury can believe some of the testimony, all of it, or none of it. And they may say the guy was driving, he didn't see a body on the thing, so therefore, reasonable doubt. I guess they could say that. Or they could say he was driving, he was hopefully paying attention to the road, which apparently doesn't always happen because he hit this other basketball hoop on the road that night, and maybe that's what he recollects. He's not going to say he's a unattentive driver, is he? No. But yet again, he thinks he's familiar with the area, but yet he doesn't recall another house that had a trash dumpster in the front yard as well. So once again, it goes to the jury to decide questions of fact. Now, the nice lady that showed up, she's a pharmacist, professional, goes out to see the band at the bar and leaves. What are you going to go into that with her on cross-examination, right? Brennan got out some good stuff. The victim, good man, kind man, caring man. Yes. And he was excited because the kids that he's basically adopted from his dead sister's, kids, he's raising on his own, they got into a private school. So there was a celebratory mode there. And she says, well, she thought everything was good between O'Keefe and Reed. But remember, Reed, by her own statements, said that they've been arguing all day. So I don't know. When you're out in public, it's a facade, I guess. I don't know. But when your own defendant is saying that they had been arguing throughout the day, it doesn't mean that they didn't put on a front for everybody. Who knows? Anyway, this witness, nice lady, doesn't really add to it. But then what does Brennan do? Hey, one last question just before I let you go. I just want to confirm it was Karen Reed driving that car, that SUV, right? Yep, no doubt about it. It was her. O'Keefe was the passenger. Obviously, once again, putting her in control of that vehicle, which obviously the prosecution's theory is that she hit John O'Keefe by backing into him at some what is it, 24 miles per hour in reverse, according to the data, which, hey, what can you do with the data? The data is data, right? Anyway, hopefully you all think that we got the facts correct today, because you certainly don't like the opinions that somebody's not doing a great job. I'm just telling. I mean, like I said, let's see. Let me just do a quick calculation here. Let's be very, very conservative here. All right, going on 30 years. Let's just say an average of 12 to 15 felony trials a year, not counting. We're not even going to count misdemeanors. All right, let's just go 12. Right. That is 360 jury trials of a felony nature over my time. But I don't know what I'm talking about, right? You don't know what you're talking about, Scott. You don't know a good fact if you saw one, really? Because like I said, the trial I just did 3 weeks ago when everybody told me it was a dead loser, and I went to trial with client's admissions, a co-defendant testifying against my client, and wiretaps, and I still walked the guy, but people accusing me, I don't even know what kind of defense attorney you are. Oh my God. Or maybe I'm just one that zealously represents his clients, but has an ethical obligation to tell the truth to the client. You don't just become a cheerleader for your client. I've seen that, particularly oftentimes in the public defender arena, where they have drank the Kool-Aid so hard that they will not concede anything. And I've seen clients go to prison for the rest of their life because the attorney said, we got to win this. We got a thing here. And instead of looking at life at the life sentence, they could have light at the end of the tunnel. So ultimately, it's the client's decision, but if you get an attorney that is overhyping their case, it could be ugly. Next, 3 missing sisters found deceased in Washington State. On Monday evening, the bodies of Paitlin Decker, age 9, Evelyn Decker, aged 8, and Olivia Decker, age 5, were discovered deceased near Rock Island Campground in Washington State following an extensive search by police. Now, the Washington State Police subsequently canceled the endangered missing person alert issued for the sisters. Now, the girls were last seen alive Friday with their father, Travis Decker, who had picked them up from their mother's residence for a scheduled 3-hour visitation as part of a parenting plan. When Mr. Decker failed to return the children, their mother, Whitney, reported them missing at 9:45 p.m. on Friday afternoon. Police initiated efforts to locate the father and the children, and then on Monday at approximately 3:45 p.m., law enforcement located Decker's GMC truck near the Rock Island Campground, and during the search of the area, the bodies of the 3 girls were found, but Travis Decker was not present. A SWAT team was deployed to the campground about 5 p.m. in the area and was closed to the public. Travis Decker remains at large and is wanted by police. He's been charged with 3 counts of first-degree murder and 3 counts of first-degree kidnapping. He's described as 5 foot 8 inches tall and 190 pounds with black hair, has it pulled back in a ponytail and brown eyes. Police have indicated that Mr. Decker, a veteran with extensive combat training, may pose a significant risk if he is approached. His current armament status is unknown, and Mr. Decker lacks permanent housing and is known as to frequent hotels and campgrounds. And with the girl's mother had previously expressed concern about Decker's mental health, noting his struggles since having left the military. The police has obviously done their normal, we extend our condolences to the family, and although the Amber Alert was considered, it was not an issue as the situation did not meet the necessary requirements, they say. However, the EMPA was activated on Saturday after additional information was provided. Needless to say, law enforcement is seeking public assistance to locate Travis Decker, but has advised against approaching him due to the potential danger. A GoFundMe campaign has been set up for the mother, and as of now has already raised $30,000 to support her during this time. Absolutely tragic. Ladies and gentlemen, I understand people have issues related to their military service. My heart goes out to them. Although I was in the military, never saw combat, so I can't say that I know exactly what they're going through. But if you need help, go talk to somebody, because there's a better way of doing it than, killing your 3 daughters, age 5, 8, and 9. Clearly, there has to be a better way. Next on the docket, shocking details about the death of Jonathan Joss, Anyway, on Sunday night, Jonathan Joss, a 59-year-old actor known for roles in King of the Hill and Parks and Recreation, was fatally shot in San Antonio outside the site of his former home, which was destroyed by fire in January. Now, the San Antonio Police Department arrested Zigfredo Alvarez Seham, a neighbor of Joss, in connection with the shooting, and according to the police report Tuesday night, Seham admitted to the shooting upon his arrest, stating, "I shot him." Seham has been charged with murder, and the investigation is ongoing. He has not yet entered a plea, and it is unclear if he has a legal counsel as of this time, but he will soon because it's a murder case. If he can't afford counsel of his choice and he remains in custody, he's entitled to a free attorney. Anyway, the San Antonio Police Department responded to over 14 calls related to disputes between these two men, indicating obviously a history of tension. Neighbors reported frequent verbal altercations, often resulting in police intervention, and a neighbor who knew Joss for over a decade described the conflict as persistent, noting frequent police presence at the scene. Then in January, Joss's home burned down, resulting in the loss of his 3 dogs, his car, and memorabilia from his 30-year career in television and entertainment. Police attributed the fire to an unattended propane heater, finding no evidence of arson. Joss, however, publicly stated he believes the fire was deliberately set due to his sexual orientation, a claim he reiterated after the incident. No charges were filed in connection with the fire. There have been allegations of homophobia by Joss's husband, Tristan Kern de Gonzalez, who issued a statement claiming the shooting was motivated by homophobia. Gonzalez alleged that he and Joss faced over 2 years of threats, including warning that their home would be set on fire, which they reported to law enforcement without any action. He further stated that the couple endured regular harassment, much of which they described as openly homophobic. Gonzalez reported that the shooter used homophobic slurs before the shooting and that the couple found the skull of one of their deceased dogs at the property, causing significant emotional distress. Estes, another neighbor, corroborated hearing Seham use homophobic slurs, including derogatory terms for gay individuals, when referring to Josh and Gonzalez. Another neighbor noted that Josh occasionally exhibited erratic behavior, such as yelling at passersby or stopping traffic, which may have contributed to the neighborhood tension. The neighbor emphasized, however, that such behavior did not justify the shooting. The police put out a statement that their investigation found no evidence suggesting the shooting was motivated by Josh's sexual orientation or constituted a hate crime, and the department committed to reviewing any new evidence that may emerge. Next on the docket, a man tries to kill his wife. This is a new one. A North Carolina man faces multiple charges after police say he deliberately caused a head-on collision crash in an attempt to kill his wife, who was in the passenger seat. That's right. Anderson Singleton's wife and 2 people in the car that he hit suffered serious injuries in the crash just before 6 a.m. on Saturday in Raleigh, North Carolina. The crash was caught on a witness's dash cam video. Take a look at this. Well, the police say Singleton swerved over the center line into the oncoming traffic, slamming head on into the Toyota Camry with 2 men inside. An off-duty paramedic was driving by and stopped to assist before the EMS personnel arrived. And court records say Singleton did not appear to be impaired at the time of the crash. He was arraigned on Monday, and a judge ordered him to stay away from his wife. He was charged with 2 counts of assault with a deadly weapon causing serious injuries, assault with a deadly weapon with intent to kill, careless and reckless driving, and driving left of the center line. The judge added charges of domestic violence, assault, stalking, and making threats, and he was ordered to be held without a bond. Next on the docket, what would you do if she turned out to be a he? So, Miami-Dade deputy who allegedly punched a woman he brought home after realizing she had a penis cleared of all criminal charges. 54-year-old Lieutenant Daniel Chala, Chala, was arrested in April for allegedly battering a transgender woman that he met at a club. According to Chala's lawyer, he drunkenly brought home what he thought was a woman. When they got into the residence, the two began kissing when Chala asked the victim a question, which confused the victim due to it being previously answered. When Chala realized he was kissing a dude, things apparently got a little physical. This person came in under false pretense, and his client escorted this person out, according to the defense attorney. Anyway, apparently this person represented at all times that she was a woman when in fact she was a man. So I saw this story and I thought it was interesting because I was hired along with another attorney. I was brought on because we thought it was going to go to trial for almost identical situation, except there were numerous meetings where this individual held herself out as a woman when in fact it was a dude. And then when they started kissing, the dude, who was a dude, all of a sudden punched the girl who was saying that she was a dude because all of a sudden the dude that was a dude punched the girl who was really a dude and saying, "You didn't tell me that you had some junk." Anyway, we ultimately resolved that case with a reasonable settlement in that particular case. But it was interesting because we made the exact same argument to the district attorney, like this person misrepresented who she was because she was a he. And this guy, I mean, it really kind of messed him up because, well, he thought he was messing with a girl. So it just shows you that jurisdictions, they can change. I mean, the DAs where we were like, this is a hate crime. How dare you do this? I mean, it's not like he's like picked somebody up and said, "Oh, you're, transgender. Let me assault you." Our client was confused and dazed very under these same circumstances. So I thought it was a good example to show it completely depends on what jurisdiction you're in, what district attorney you get, and basically how they feel about a particular case. Next on the docket, this day in legal history. On June 4th, 1928, the United States Supreme Court ruled in Olmstead versus the United States that wiretapping without judicial approval did not violate the Fourth Amendment, influencing privacy laws until overturned by Katz v. United States in 1967. On June 4th, 1930, federal agents raided illegal speakeasies in Chicago, continuing to target organized crime, exposing police corruption, and obviously supporting prohibition, which obviously was eventually repealed. On this date, in June 4th, 1957, Congress was debating the Civil Rights Act of 1957. It was passed in September, establishing the Department of Justice Civil Rights Division to enforce voting rights. And on June 4th, 1984, the United States Supreme Court ruled in Shaw v. Martin that preventative pretrial detention of juveniles is constitutional under certain conditions, impacting juvenile justice policies. These days, unless you got a gun and it's a crime of violence, you're a juvenile, you're going to get a bond, assuming you can be returned to the home. Sometimes you're going to be placed in some sort of residential thing, residential treatment, residential housing, something along those lines. But unless it's a gun, usually here in Colorado, a gun and a juvenile, you're going to have to do 5 days. So they usually keep you for 5 days and then they release you so that you can say you got your credit time served. Next on the docket, our quote of the day. Well, it's regarding witness memories. So the following quote addresses the reliability of witness memories and their ability to recall and recollect events accurately. Now, the vagaries of eyewitness identification are well known. The annals of criminal law are rife with instances of mistaken identification, a major factor contributing to the high incidence of miscarriage of justice from mistaken identification has been the degree of suggestion inherent in the manner in which prosecutions present the suspect witnesses for pretrial identification. That was the 1967 case of United States v. Wade from United States Supreme Court. And that quote highlights the challenges associated with witness recollection, emphasizing how memory can be influenced by external factors such as suggestive identification procedures, which may impair the accuracy of what a witness actually recalls. Which reminds me of one of my favorite quotes from a great book, Murder in the Bank Vault. Great story about the Father's Day massacre here in Colorado, where 4 bank security guards were executed and money stolen. And a former police officer was charged with the case, and he was ultimately acquitted. It started off as a death penalty case. And the defense attorney, Walter Garash, a great trial attorney who only passed away, I think maybe 2 years ago, he used a quote from the FBI forensic manual at the time. And it reads, "Wherever the criminal steps, whatever he touches, whatever he leaves, even unconsciously, will serve as silent witness against him. Not only his fingerprints or his footprints, but his hair, the fibers from his clothes, the glass he breaks, the marks he leaves, the paint he scratches, the blood he deposits or collects, All of those and much more bear mute witness against him. Obviously, this was written before DNA. This is evidence that does not forget. It is not confused by the excitement of the moment. It is not absent because human witnesses are. It cannot perjure itself. It cannot be prejudiced, be influenced by suggestion, by falsely reinforced identity. It cannot be wholly absent. Only human failure to find it, study it, and understand it can diminish its value. Good quote, ladies and gentlemen. That's why so many people like corroboration, right? Prosecutors are always looking for corroboration. The defendant, even if he confessed, let's corroborate that that's actually what took place. It's all about corroboration. What was the weather like? Here's the weather report from that day. They're always looking for corroboration. Hard data, physical evidence that corroborates the witness's statements. If they're not able to be corroborated, well, sometimes it maybe not as reliable. And most false people have been convicted wrongfully and have been released. Usually it is eyewitness identification. It's not exactly the strongest thing out there, indeed. So be careful of eyewitness identification. And finally, on the docket today, our dumb criminal of the day. A married couple was arrested Sunday evening for allegedly engaging in some lewd activity at the Sidewalk Cafe in Florida. Please meet Ryan Cook and Kimberly Morey, who were at the Where's Jubes bar in downtown St. Petersburg when they were arrested for disorderly conduct. Now, according to a witness, Mr. Cook allegedly placed his hand up his wife's dress and touched her private parts, which reportedly caused a disturbance and a breach of the peace. Now, Miss Morey was charged for allowing her husband to place his hand up her dress and engaged in the alleged sexual conduct. Now, according to the arrest affidavit, it does not identify the witnesses who fingered the frisky couple. Mr. Cook and Miss Morey were each charged with disorderly conduct, a misdemeanor, and possession of an open container. During their court appearances on Monday, Mr. Cook and Miss Morey pled no contest to the charges, and the judge adjudicated them guilty and fined them each $500. The couple was subsequently freed from the county jail. I guess you'd have to ask Miss Morey if it was worth it. And Mr. Cook, I guess, as well. Anyway, that's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time. And remember, the Constitution matters.